How do we ensure that doesn't happen?
Yeah, with the greatest respect, yes, I know that my Lord Justice Abang made reference to that, but I would rather think that, for me, that that is something for the Court of Appeal to see, because to make such reference to a sister court, it will appear as if my Lord Justice is standing on appeal, even though he made it clear that he's not wrestling, jurisdiction with the Port Harcourt. But I would rather think that he would have left it there without going further. To do what he did is even enough to be appealed against. I mean, the PDP or the Caretaker or whatever can even appeal against that, to even imply that it's like my Lord Justice has come into the arena of the conflict. So I would rather think that my Lord Justice would have just stayed away. He probably may have given his order, because based on what he has before him. And I would expect that he wouldn't have come up with every other extraneous point that he made. But that is for the court, so to speak, because he has the file before him. He knows what was presented for him. It is based on that he gave his order. Yeah. But like I said, he didn't give a judgment. But I am more concerned of the fact that, look, I would not have bothered myself with either the order given by Wakil, that is the latter order, and because that is where the conflict commenced. Because if they have taken into consideration only that of Liman, there won't have been anything like conflict as far as I'm concerned.
So in other words, they shouldn't have gone to court when the order of Justice Liman still subsists, especially if it had not been appealed and successfully appealed against.
Who shouldn't have gone to court?
The Senator B case.
So basically the going to court may not be unconnected with the fact that they have gotten wind of this matter before Justice Abang. So, in other words, and for me, it's even wrong, as it were, because Liman's judgment was clear, so to say. So, the only thing is that they have ended up dragging the judiciary into politics.
Because some lawyers have said, look, since there's also Justice Waleta's order, that it wasn't that positive, and so when Justice Abang's case came up... What is it not positive? When it wasn't categorical.
When he said, ensure that you... that the convention, he said the convention is valid and subsisting.
Some thought that he didn't say, go ahead and hold your convention. It was about the members of the committee and not the party. They didn't go as a party, they went as members.
My brother, let us tell ourselves, let us be honest with ourselves. The truth is that the judgment of Justice Wakil was very clear. Just like the order, the judgment of Wakil was clear because it was the judgment. The order of Honorable Justice Abang was very clear, equally. That is why are we then talking about conflict in the first instance?
Not predicated on Justice Liman and Justice Abang?
That's what I'm saying. No, I'm saying that I'm talking of Wakil and Abang. We talked of conflict because of the way the orders were made. In the absence of the clear orders, there wouldn't have been conflict, so to speak. So if we are not saying that the Wakil was not...
Okay.
If we are saying that the order of Justice Wakil was not clear, then why are we then talking of conflict with the order made by Justice Abang? There won't have been anything like the issue of conflict. Okay. So for all intents and purposes, it is my view. I humbly believe that with the greatest respect, for me, the most important judgment in respect of this matter is the one given by Liman. And not until it is set aside, it remains subsisting and valid.
Markwa, go ahead.
What do you say to those who accuse both parties of judgment shopping?
That's forum shopping. Well, just like what I said before, that it's unfortunate that where the politicians are dragging the judiciary into politics. Because I would rather think, with due respect, after Justice Liman's judgment, such matters, when they came up before our justices, so to speak, except probably the facts are not before them. But as long as the facts are before them, they only say, even if they want to make any comment, they will raise their hand. Just like one Honorable Justice Kolawole, in respect of the Kogi Embroglio. It's not as if he couldn't have given a judgment in respect of him. But having seen what it is going to create, he just quietly and smartly said, no, this, I don't have jurisdiction.
Okay.
You go to... So, and that is the only way you will avoid this, so that let the apex court deal with it.
Let's take a moment. We'll be back. Don't go. Welcome back to Sunrise Daily World Development, just happening quick and fast. And today we've been able to see that police can respond real fast in terms of some cases. Even courts can move very fast about some cases, but we all know, as Nata was going to raise that, look, there's several other scenarios that they don't move this fast. Is it because of politics?
I think, don't forget that when we say the law has the effect of, in fact, it touches on the entire society. And when we talk about social engineering, we are looking at a situation where whatever judgment you give will not have a damaging effect on the entire society. And politics has the capacity of snowballing into what you may call anarchy if it is not well managed. So that is why when they come up before our courts, as long as it's a political matter, it is given priority over every other matter, so to speak. And that is why, for instance, the Supreme Court has even made the order that pre-election matters, for instance, and election matters should be given priority. For instance, the 180 days you have in the Constitution where the tribunal must finish any election matter, election tribunal matter, it is because of the danger in delaying it and the ridicule it exposes the nation to. Bear in mind that it is time inclined, so to speak. If you understand what I'm saying, when I say time inclined, you have somebody who will be there for 4 years, and you now want to delay his matter the way you want to delay normal matter. And at the end of the day, he probably may get justice, but will not be able to enjoy the benefit of that office.
All right, let's bring
now the implication, therefore, is that on the next time you say that you shall this, he want to employ self-help.
I
was just wondering, you know, at the end of the day, how do you see that this is going to be resolved? Yes, you already talked about the injunction. You said you heard with. Can we really rely on that?
Heard with, as in, I said I heard this morning that there was an appeal as well as a stay that had been filed. How true that is? It's over the media. I heard it this morning when I was coming out.
But is that sufficient if you just filed it?
Well, it's an indirect way of trying to confer some element of legitimacy on the part of the authorities who probably will act in favor of the order that they want to carry out the convention, so to say, so that it will not look as if the Form 48, because there is that Form of 48 on content that has created the entire problem, as it were.
Wow, that's how it all is, and how we end as well today on the program.
Would it really hold water?
Well, my apologies. We'll have to just wrap this up. Matthias Mary Bay, legal practitioner, we appreciate your comment on this morning. But I'm sure the matter will develop as it also is, and our correspondent will also bring us up to date as it progresses. Well, that's the show today. We thank you all for watching. I'm Chamberlain Oso.
I'm Neota Igwe.
And thank you, Maokwe Ogun.
It sounded like you didn't want to go. We'll see you tomorrow.